Everyone. Welcome to today's Q&A and live stream, where we will discuss the questions submitted by some of you and some frequently asked questions that we came across this week. And we'll discuss the updates regarding the end to flag polling and few other things like a success story and a case law that help us change one of the decisions by the IRCC. So first question was submitted by one of our somebody who had taken a consultation previously. The requirements for an employer-specific work permit after the PNP approval. Okay. So there are certain requirements, but the most important one are work permit support letter, provincial nominee approval, compliance fees if your PNP is closed or if you don't have a acknowledgement of a SIP for your PR. And then very importantly, if you are a truck driver or a security guard or working in any occupation that requires a license, make sure you put your license along with your proof of your education and a work experience in Canada or outside Canada that can prove that you can do the duties of that job in Manitoba or in any other province. So very important, some people are getting refusals. It's employer specific work permit T13. Make sure you include your license if you need one to do your job. For example, if you're a truck driver, make sure to include your license in Canada. Can I work full-time during the winter break if my studies are completed and I have yet to receive my completion letter in Canada? The answer is yes, because winter and summer and spring, those are considered official breaks by the IRCC. And for example, a lot of people have written their final exam in December, around December 20th, and now they have not yet received a completion letter or an official transcript. So what are they supposed to do in the meantime during this winter break? The answer is that they can work full time because it's considered official break by the IRCC. I studied in Ontario and now I have a tier 1 job in Nova Scotia. Can I apply for express entry stream of the NSPNP? The answer is no. If you have studied outside Nova Scotia and have gotten a PGWP and then subsequently got a job in Nova Scotia that falls in tier 1, 2, or 3, you cannot apply for express entry stream of the Nova Scotia PNP. That's one of the requirements. However, if your spouse has a job, if your spouse is in Canada and they have a work permit and they have a job that falls in one of these categories, then yes, then they can apply for Nova Scotia PNP. So this one is very common. A lot of refusals under the public policy that was in place for Manitoba, Alberta, and one of the provinces up north. Got my work permit refused I live in Winnipeg. What options do I have? Well, if you are still in Winnipeg, you can resubmit your application before December 31st because this policy is in place until December 31st. So if you have been refused, you should probably work on resubmitting the application. My study and work permit expires on March 30, 2025. Do I need to apply for visitor record or extend my study permit? You should apply for a study permit, and the work permit you're referring to is probably the co-op work permit. So it'll be ideal to apply for both of them 30 to 60 days before their expiry, because you're supposed to complete your studies with a valid study permit in order to be eligible for a PGWP. So I recommend do a extension in around February. As a graduate from Ontario province, what's the possibility of me getting a PR here in Manitoba? What's the best pathway? Well, the best pathway depends on your individual circumstances, but the one that works for almost everybody is the skilled worker in Manitoba, especially if you can land a job in healthcare or technology sector. Then you are a very good fit for the skilled worker in Manitoba stream. So make sure you get your IELTS or CELPIP score as much as you can, and ideally land a job in Manitoba in education or healthcare sector or IT sector. Those sectors have seen a lot of invitations during this last year, and it will continue well into 2025, because those are the people that the employers in Manitoba really need. So it's a good chance, but don't come to Manitoba if you have only 6 months left on your work permit, because there's nothing they're going to be able to do. My studies completed more than 90 days ago, but my permit expires in March. Can I study in Jan 2025 as per the new rules? The answer is yes. So there are two things when it comes to the expiry of your study permit. Okay. Well, three things. One is 90 days from the completion of your studies. Okay. Second is the expiry date that is listed on your study permit. And the third is, do you plan to study in Canada within 150 days of you completing your previous program? If the answer to that question is yes, like in this cases, then your study permit, believe it or not, is still valid and you can use it to study your new program. However, you do have to submit an extension as per the rules that were recently announced, and you can continue studying until the date your study permit is valid, as long as you submit an extension of your study permit as soon as possible. So end to flag polling on December 23rd with limited exceptions. Let's talk about this. One moment, guys. So there you go. Much awaited announcement. In this was done in response to the threats by the new president of the United States. Our immigration minister kind of admitted to this, and it was quite sad because Canadians have been asking for a lot of changes. They did not happen, but as soon as there was threat from President Trump of tariffs, then the government was woken up by this threat. So December 23rd was the last day people could do flag polling. This practices significant resources at the border, officers away from important enforcement activities, and that has contributed to wait time for cross-border travelers. So a lot of people might think, why did they just change it? Why not just keep it in place? Well, the thing is this: in BC and Ontario, some consultants or lawyers, they were taking bus loads of people to the border, and like 50 to 60 people per day. And what was happening is those 50 to 60 people needed to be processed by the US border, and then they were turned around. It was taking you can imagine, if that happens once a day for year after year after year, it's going to take up a lot of time away from like the actual job that the border people have, that is processing people coming into and checking their vehicles and whatnot. So you can see this practice has taken up diverting Canadian important wait time across the border travelers. So further streamlining at the port of entry. So you can see the numbers here. Between April 1st, 2023, within a year, 69,300. If we do that math, let me see how many that averages to per day. Okay, 69,300. That's like 190 people every day. In a very there you go. There are some exception to as well. Citizens and PR of the USA, they can still do it. There are these free trade agreements, which is CUSMA South Korea, Chile, Panama, Peru, Colombia, and yeah, their spouses. Now, this is an interesting one. International truck drivers who hold a work permit were required to depart Canada for the purpose of their employment. Okay, so this is basically saying if you held a work permit and you applied for that work permit before going to the USA and you have maintained status when you come back, that is when you can apply for a work permit, employer specific work permit at the border as per these new rules. So only exemption is for truck drivers. Everybody else must do online. I don't think they're going to make any inland centers for people to go and apply on a daily basis. So that hope is gone. And these people who already have a appointment booked with the CBSA for permit processing. I don't think there are many people who fit this category because they had stopped booking appointments a while ago, and then they sprang this news overtime on people, so they're not going to have a lot of appointments, and the people who will benefit from this exemption. Now, I wanted to share one success story and wanted to discuss a case law that helped us help this client. So what had happened was somebody applied for a work permit. They were asked for a document which they failed to submit on time, and this resulted in refusal of their work permit. So they came to us after I think, about 3 to 4 months after the refusal. I looked into the case and I thought the reconsideration could do something. We went ahead and did the reconsideration, and the application was put back into processing on December 24th. Let me just share something very quickly. And this is the case law that we are going to discuss today. Very, very, very important case law in the context of work permits and post graduation work permit, especially, and compliance with the conditions of the study permit. Okay. Okay, guys. So let's discuss about this case law. So this was the refusal of a PGWP. You can see here. This happened back in 2020. Okay. Simon Fraser University. This guy came into Canada in 2012, so it took about 8 years. Okay. Decision as part of his application, part-time enrollment and gap in studies. Okay. So these are the most common reason for PGWP refusal: part-time enrollment and gap in studies. In spring 2017, mandatory course, he paid the fees late due to the shortage of foreign currency in Zimbabwe. Late registrations in the course was full by the time applicant attempted to enroll. He was not able to meet the criteria. Okay, this was only spring 2017. And then importantly, this is the most problematic semester. 2018, shortage of foreign currency that delayed the payment of the applicant's tuition fees despite the applicant's parent processing the necessary funds. So basically, you can see here the applicant and their family were struggling, and they did everything that they could. So here, officer refused the application, did not meet the requirements for a PGWP. There you go. So the officer thinks there was a gap of more than 150 days and did not change status to a visitor during the missed semester. Okay. The officer is not satisfied and the fall 2018. You see, this is the fall 2018, where the applicant's family was having some financial problems back home, and they had some sort of documentation. And you can see in officer's notes, he's referring to the same. And he had provided an explanation for his part-time enrollment as part of the application. This is very crucial, because if you don't give explanation to the officer, how are they supposed to know? So they're not required to ask you anything. It is your duty to give them the context ahead of time, so they have everything that they need to make a decision on your application. And then this application was refused, and in December filed for leave and judicial review of the decision. This is a fancy way of saying that the applicant challenged the decision in the court. Now the issue that was decided by the court. So now in declaring the applicant, he did not change. There you go. So let's go through here. This is just boilerplate. Now the applicant agreed, were interrupted. Now this is important. The individual circumstances of the applicant, strong equitable factors at play concerning the applicant, and bearing in mind the particular so individual assessment under the law by the officer is required whenever there's a decision. So they cannot say, I'm just refusing you because you don't meet the requirements. They have to take into consideration all relevant factors that were outlined by the applicant. And now the discretion element here. And they also argued that the applicant comes from Zimbabwe, which is an underdeveloped country, and there was issues with the foreign currency, and it was not equitable under the law that the officer did not consider the fact that there was problem with the foreign currency reserves in Zimbabwe. So basically, let's go here. Now, the judge is basically looking at the requirements that are outlined on the IRCC website. Very technical, but important. Have a valid study permit when applying, maintain full-time student, submitted, completed, that is 8 months, have received a transcript and an official letter. That's it, right? And then now the judge goes into the technicalities of the decision. Problematic gap studies is the fall 2018 semester when the applicant did not study, because here the judge is saying that as part of the compliance with the conditions of your study permit, you're only required to study part-time. Okay. Now he goes into this. Very important. So you can see this is the heart of this decision, this paragraph 25. While the jurisprudence of the fact that nothing in the PGWP PDI confers any discretion on immigration officers to modify or waive the eligibility requirement, it does state that the officer should exercise their, look at this, best judgment and take into account all relevant factors when assessing a student's compliance with the study permit condition. Okay. And then the final decision here. The decision was unreasonable because the break in the studies for the applicant happened because of shortage of foreign currency in Zimbabwe, and the fact that the officer ignored that evidence, did not even engage with it, makes this decision unreasonable. This decision is landmark when it comes to PGWP, because a lot of people end up with breaking their studies with part-time semesters due to circumstances beyond their control. And this decision, if you understand it, the principles outlined in this, and you can apply it to your circumstances, it gives your application a very, very good chance of being approved. This was the lawyer. If any of you have any problems with PGWP applications, you can always reach out to him, and This was the date of the hearing. This was the date of decision, July 29, 2021. Very relevant decision even today, even though it's more than 3 years old. So now we understand this decision pretty well. And I'm going to share a case where we applied this, and the case ended up being reopened by the IRCC officer. One moment. So this is a success story. Well, success story in progress, I would say. So what had happened was the applicant came to us back in May or June. Okay. So he had submitted an application in December 28, 2023. That is almost a year ago. Okay. Long story short, there was a request. He did not provide the officer what they needed. Okay. Ended up with a refusal letter in April. April 15, there's a refusal letter here. So in around May or June, we had a consultation and we submitted a reconsideration request. And on December 24th, the client got a Christmas present. You can see that his application was reopened after close to 7 months. So now we submitted the documents. We're just going to wait for the final decision from the IRCC. So this happened because we understood that case that I discussed and how it applied to clients' circumstances. So that's all for the success story today. One more. Now 50 points for the arranged offer of employment gone from spring 2025. Yeah, this was another big one. This last week, they're gonna do away with this PR stream LMIAs, and the people who are already here on LMIA based work permit working for their employers for a period of 1 year. Those people used to get 50 or more points depending on what their NOC was as part of their express entry profile. Well, no more from spring 2025. What is the exact date? Well, we don't know. I think the spring starts around March, late March. So it's probably around that time that they will just spring it on people that effective this date, we are stopping this 50 arranged offer of employment points for people in express entry. But I also want to say one thing. I think it's quite fair that they're giving people until spring 2025 because a lot of people have put in a lot of hard work. I know there's some fraud in the system, but that's always the case. No matter which system you work in with the government, there's always going to be some fraud. But I think this is very fair that they're not cutting these points overnight because there are people who have submitted the LMI applications in April for PR stream and they're still waiting. So we'll know more in March of 2025. I think the season of changing rules is not going away from Canadian immigration anytime soon. We expect to be very busy early 2025 and into throughout 2025 because a lot of people's permits are expiring. A lot of people are struggling to stay in this country. The government wants to reduce the number of the temporary residents, which is going to be very, very challenging for them because not a lot of people are willing to leave Canada after they have spent a lot of money coming here, studying here, and then worked here on their work permits. So it's going to be interesting to see what happens in 2025. But one thing is for sure that the changes in the immigration system will not stop. Immigration is going to get quite tough as it already is. And I I encourage everybody to just take what they can. For example, if you're eligible for PNP, just do it. Don't obsess over express entry. If you are considering marrying, just don't wait. Just get married. As long as they're genuine, obviously. So get your immigration sorted out. Do not leave it to the last moment. Do not procrastinate, importantly. And I wish everybody happy holidays. We'll be in touch on Saturday again. I hope everybody had a wonderful Christmas. If you guys have any questions, leave us in comments or follow the link to submit your questions for the next Q&A that will happen on Saturday. Thank you and good night.